Good afternoon, and welcome to our webcast, Moving Past the Great Resignation, Employer Strategies for the New Normal. For those of you who I've not met, I'm Dan Meyer, publisher of BizTimes Media. Thank you for attending today's webcast, which is presented by InCheck and Reinhardt Berner Van Buren, and brought to you by BT360 Content Solutions, the marketing storytelling arm of BizTimes Media. As we are hopefully coming to the end of COVID-19 as a pandemic, it appears that the workplace has changed forever. Today is less about turning back the clock to return to normal and more about embracing the realities of a future workforce that, while changed, presents both opportunities and challenges for employers and workers alike. But how does this impact your hiring and employment strategies? How might you update your HR policies and practices to address ever-evolving issues, including remote work, vaccinations, and accommodations? As an employer, do you have the tools and knowledge you need to build a robust and stable workforce in the new employment reality? Our presenters will discuss the following topics: updating your employee manual and restructuring your hiring process to meet new challenges, addressing data security and privacy risks through HR policy and practices, screening and hiring in a tight labor market, vaccinations and COVID testing, the latest updates, fair chance employment, and much more. Plus, at the end, we'll have a Q&A. The slide deck for our program is available now. If you want to take notes and follow along, you'll find the link in the chat button on your screen. Later today, a recording of the program will also be accessible on our website. At the conclusion, you'll also find an attendee survey, and we would appreciate it if you would fill that out to help us plan for future webcasts. Before I introduce the speakers and continue with the program, I'd like to mention that we're celebrating our 27th year as an independent, family-owned business, and BizTimes Media is the only locally owned business media company in the region, and it wouldn't be possible without your support. Whether it's attending events like this, print or digital advertising, event sponsorships, or BizTimes Media's BT360 Content Solutions, I guarantee that we'll continue to work hard every day to earn your business and to help you grow your business through our custom and integrated marketing programs. If you're interested, please contact our sales director, Linda Crawford. In addition, our award-winning editorial team is always looking for story ideas, especially if your business is expanding or moving, or if you're buying another business or building, or if you have any other news, operational insights, or other information you'd like to share. Please let us know so that we can help you tell your story. And in 2020, we launched our Insider Subscriber Program. Thank you to all the insiders attending today's program. For the equivalent of $8 a month, you can be an insider and receive several insider benefits, including access to all the content produced by our editorial team. And it's also your opportunity to support local journalism. Before I introduce the presenters, I want to mention again that today's webcast is being recorded and will be available on demand on our website later today or by tomorrow morning. So let's meet our presenters. Rachel Moravchik is Chief Operations Officer with InCheck. InCheck offers customized pre-employment background screening. Rachel oversees the strategic operations of the investigations, verifications, occupational health, compliance, and client services teams. She has a 360-degree view of the organization and works closely with InCheck management and leadership teams to maximize efficiency and quality. She leads the team in setting strategic company and department goals and ensuring legal compliance and industry standards. Rachel, welcome and hello.
Thank you, Dan. Happy to be here.
Thank you. Michael Gentry is a shareholder and labor and employment attorney with Reinhardt Berner Van Buren. Reinhardt has been providing legal counsel to business leaders, entrepreneurs, and innovators since 1894. At Reinhardt, Michael represents his clients through all stages of employment counseling regarding discipline, leave and termination decisions, and regularly represents them in litigation involving non-compete and non-solicitation issues, alleged discrimination, and in-wage and hour class and collective action matters. As a member of Reinhardt's data privacy and security sub-practice, he also helps his clients develop employee-facing policies and agreements to protect their client or their customer relationships and confidential information. Welcome, Michael.
Thanks, Dan. Happy to be here.
Great. So let's move on to the program. Following the presentations, we'll likely have time for a Q&A, as I had mentioned. And please remember to submit any questions that you have using the Q&A feature on your screen. And you can also find the slide deck on the chat feature. Again, the slide deck is on the chat feature, and if you have questions, use the Q&A. So let's get started. Michael, what legal issues would you say characterize the new normal for employers?
Thanks, Dan. Hi, everyone. Happy to be here. Thanks for joining us. So in terms of discussing the shifting legal landscape that employers are facing, what I would suggest is considering it in two separate buckets. First, what has changed about the legal landscape that employers must confront because governments and agencies have taken action that require employers to do things? And second, what changes about the employment relationship beyond those laws further justify adapting legal strategies? So during the presentation today, with regard to the first section, we'll discuss shifting data privacy and security requirements. As we all know, the pandemic pushed everyone online even more, but amidst that chaos, states continue to take steps to pass legislation protecting, to certain extents, their citizens' personally identifiable information. And until there's federal legislation in that arena preempting state laws, companies need to be aware of what laws apply to them and what they require. Second, COVID-19 will continue to be an issue even as the pandemic does seem to wane. Despite the Supreme Court's ruling overturning the OSHA emergency temporary standard, OSHA will have ongoing requirements to maintain safe workplaces as it relates to COVID-19. And similarly, the EEOC has updates that employers need to take into consideration as they move forward. Both COVID and remote work will complicate employers' analysis about whether someone has a disability and whether they are entitled to a reasonable accommodation. So then in terms of the second bucket of things that employers should consider, employees have more bargaining power. We know that now. This justifies looking at your hiring practices. Like, do you require employees to sign agreements when they join? What do those agreements contain? And in what ways can you reshape your employee handbook to address issues like remote work, technology, and confidentiality? Next, remote or flexible working relationships will often bring employees in new states. Many employers aren't aware that when that's the case, they may need to comply with new or even multiple states' laws for a given remote worker, which just creates another layer of complexity. And lastly, inflation and disruptions to supply chains and customer relationships. This can be key, especially for sales-based employees who are bringing in now fluctuating amounts of revenues per month and who may be tempted to leave during the Great Resignation. And as a result, now is a good time to look at the enforceability of the agreements with those employees, both things like confidentiality agreements and even just compensation agreements, especially with regard to things like commissions and bonuses, to see whether they're clear about what's the basis for a particular commission, when is it earned, and what is owed if an employee does leave. So that's just a general overview of what we'll discuss today, and I hope we get into more detail. Thanks, Dan.
Great, very, very interesting, Michael. Thanks. Rachel, keeping in mind the dynamic shift in employee bargaining power that Michael just mentioned, what are ways employers can adjust their recruiting and retention strategies to adapt to a predominantly remote workforce?
Yeah, Dan, the predominantly remote workforce is actually, in my opinion, an opportunity to expand geographically. So take In Check, for example, we were a predominantly Milwaukee-based organization, and we pretty much had everybody in office. This has been an opportunity for us to really expand our talent pool. So we now list our job openings as remote. And by doing so, we've attracted talent from Utah, Ohio, Arizona, Michigan, Florida, South Carolina, just to name a few states. And so this has really expanded our talent pool, especially in a niche industry like background screening, but it's not without challenges. Like Michael mentioned, it creates unique challenges for organizations when you're considering state-specific laws. There are also challenges with onboarding. And that's particularly the case for any employer that's used to paper forms. So online applications, applicant tracking systems, HR software, e-sign software, electronic consent forms, and remote Form I-9 and E-Verify are just a few examples of ways to streamline your hiring and onboarding for the remote environment that we're now in. And a lot of these can be really big ticket items, but there's certainly cost-effective ways for employers to implement some changes. And these are technologies that employers that are predominantly in person can also utilize just to streamline their processes. In today's race for talent, reducing the time between application and first day onboarding is critical. And that brings us to virtual training. That's a challenge in today's remote environment. And, a lot of people think about learning management software, which is a great tool, but also a really big ticket item. So solutions like Zoom, which we're all on today, or Teams are really great for facilitating training. And it's really important that new hires have a direct face-to-face contact with their manager, their trainer, and their colleagues. We also recommend collaboration tools like Team or Slack to facilitate connection and engagement. And culture is really critical in determining whether or not employees stick around. InCheck was actually one of 5 finalists in the Wisconsin Fire Awards for the talent category in 2021. So I'm pretty confident in the talent retention initiatives that we've implemented. A few examples of those include our monthly all-team meetings, in which all of our team members will hear from our leadership. We also provide department updates. We welcome new team members. We celebrate birthdays. There's a volunteer spotlight, so it gives opportunity for team members to share their volunteerism. And then we send out a post-meeting survey with each meeting. So it's an opportunity for our employees to tell us what they'd like to hear from us. All of our team members utilize Zoom, so that really helps with facilitating collaboration and engagement. And we've also implemented DEI initiatives, including an annual Day of Understanding, a DEI summit, and we are looking to bring on virtual speakers. We also continue with Employee Appreciation Day, which actually was last week. I'm sure a lot of employers were involved in that. I saw a lot on social media about that. So we will host games for our employees, and we also have a happy hour. I think our happy hours are always everybody's favorite. And we also send new welcome kits to new employees. So that includes InCheck swag. And to not leave out any of our current employees, we did actually send out new swag to all employees at the start of this year. We also have a collaboration platform. As I mentioned earlier, a lot of the companies use Teams or Slack. We use something called River. And the reason we chose River is because it is a really cost-effective solution. So we started using it as project management software. And then when everybody went remote, we started using it to communicate with our teams. So we use the platform to celebrate birthdays and anniversaries, give team members shout outs. Our managers will share a question of the week. Those always have really funny answers and oftentimes some fun pictures that our team members will share. And then we have a culture committee that shares social events and volunteer opportunities. And we've just initiated this year a DEI educational forum on River. So we focused on Black History Month in February. We're currently focused on Women's History Month. Next month is Autism Awareness. And then we plan on focusing on mental health and LGBTQ initiatives in the future and continue to seek feedback from our team members on other areas that they'd like to create awareness around. So while we are really fortunate that we have a marketing team and an HR team, and they do a phenomenal job of employee engagement, but I think some of these strategies are ones that can be easily implemented by smaller organizations. And while culture is certainly key to employee retention, it's also that important that your employees understand how the work they do ties into the overarching goals of the organization. Employees today want to find value in the work that they do, and they also want to be valued for that work.
Right. Great insight. What advice do you have for employers who are looking to hire remote employees but are concerned that they may take advantage of the remote work environment? I think that's probably a pretty common thought.
Yes, yeah, that's a great question. I heard it a lot over the last few years, and I know that some employers even consider installing employee monitoring software. One of the greatest lessons that I've learned as a leader is that if you don't trust someone, you cannot lead them. And so while I'm not here to tell anyone how to do manage their business operations, at InCheck, we do not do any sort of monitoring on our employees. We found that the approach that worked in office still works today. And so along with utilizing our metrics dashboards, we really drive communication. So clear communication around performance expectations really is the key to managing team productivity. We reinforce productivity by setting both team and individual goals and then incentivizing those goals. And honestly, when you hire the right people and you have the right metrics in place, you don't need to worry about whether or not they're doing their jobs.
Great point. Really, really good insight. The shift from paper to electronic processes is certainly an opportunity for employers to create efficiencies in their onboarding process. Michael, what are some of the developing data privacy and security requirements employers should be aware of?
Yeah, so we wanted to include the changing data security landscape as part of this presentation, because as companies hire more remote workers, they may unknowingly fall under new state laws outside of Wisconsin that regulate their activities regarding what they do with state resident data in those states. So this evolving patchwork of state laws is going into effect over the next couple of years, and we expect that to just increase as the years progress. Generally, these laws place certain obligations on companies that they apply to. They require companies who process and control personally identifiable information to obtain consent from individuals before processing their data, and disclose all the purposes that their data are going to be used for. And they generally provide other data subject rights as well, including to withdraw that consent as they so please. These laws typically have thresholds for applicability to companies based on the number of residents' data that the company is processing even in that particular state, and the company's level of revenue. So specifically here, we've listed the Colorado Privacy Act and Virginia's Consumer Data Protection Act, both of which will be effective starting next year. Utah recently just passed a bill yet to be signed, but it also will go into effect in 2024. And these state laws join California in having comprehensive data privacy laws that employers that have operations or employees in those states should be aware of, and at least know threshold issues about whether they apply. California Privacy Rights Act, the CCPA actually went into effect in 2020, the California Consumer Privacy Act, but beginning in 2023, the California Privacy Rights Act will supplement that, including with application to employee data. So this could be a significant burden for employers with California employees. There will be new consent requirements for employee consent and new employee rights to review, including the ability to alter and obtain their personal information that the employer stores. Just in case you were wondering, Wisconsin Assembly did pass a bill about data privacy as well. I know, as far as I know, it's tabled right now because of the end of the session. It does actually exempt employee data, but for many companies of a certain size in Wisconsin, there will be requirements around the processing of personal data based on their size and their consumer relationships. Around half the states also require a certain level of reasonable security measures for the handling of personally identifiable information, even if some of those other laws that I just discussed don't apply. Around half of states require that. And that often includes employee data. Multi-factor authentication, use of virtual private networks, and encrypting are some of the typical tools that are required by the law, or even just best practices to pass scrutiny. Also, data breach laws also or often are not triggered if stolen data is encrypted, providing yet another reason for employers and just companies in general to encrypt any personal data or sensitive information that they store. Additionally, the last 2 points we have on the slide here relate to the Federal Trade Commission, because the FTC in the last 6 months has expanded its regulation of data security. In October, the FTC amended its safeguards rule under the Gramm-Leach-Bliley Act, which regulates financial institutions. The rule expanded the agency's definition of what qualifies as a financial institution, which means more organizations beyond just banks, like mortgage brokers, dealers, and payday lenders, now have to have a comprehensive security program to ensure the confidentiality and security of customer data. And additionally, in December, the FTC announced an enforcement program designed to go after companies with government contracts who fail to maintain the representations about their data security mechanisms that they use to procure the contracts from the government in the first place. And that could result in false claims liability, either because the FTC itself has cited the organization, or the FTC empowers individuals like employee whistleblowers to file lawsuits called key TAM actions against companies that will also result in false claims liability for failing to meet those representations about data security.
Great. Michael, earlier you mentioned that COVID will continue to shape the employment relationship going forward. Could you talk a little bit more about that?
Absolutely. So everybody on the call likely knows that the Supreme Court invalidated OSHA's emergency temporary standard order back in January. That means there's no current requirement for all large employers to implement a vaccine or test rule. However, what we wanted to stress on this call is that OSHA's general duty clause does apply to all employers, and it will continue to be a resource that OSHA uses to cite organizations going forward. And this will likely result in employers engaging in best practices around masking and social distancing as the CDC continues to kind of shift its guidance around what should employers do in the workplace. The general duty clause just generally requires companies to maintain a workplace that's, quote, free from recognized harms. But even though that is very general language, the law allows OSHA, just based on that provision, to cite employers for failing to do so. OSHA generally follows CDC guidance, which makes it challenging both for employers and the agency, because the CDC has been changing its guidance quite a bit. In fact, loosening its restrictions so much so that 70% of the country is now under a rubric of no mask requirements are recommended by the CDC. And so we wouldn't expect OSHA to cite organizations for failing to require masks in that situation. But in the event of another wave, COVID wave or something like that, then it could be that CDC could change its guidance and OSHA could change its practices. Also regarding to OSHA, there will be ongoing record keeping requirements for workplace related COVID cases and deaths in certain circumstances. And finally, it was actually just in the news yesterday, but OSHA is focusing on finalizing a permanent COVID-19 healthcare standard. And this is likely going to be primarily relating to masking, potentially social distancing. We haven't seen that yet. In terms of the EEOC, COVID, as the EEOC understands it now, COVID may either lead to or be itself a disability under federal law. So the EEOC supplemented its guidance related to COVID in December. And now it's clear that according to the EEOC, employers cannot be dismissive of COVID when it no longer is contagious in an employee, because it may present ongoing issues for an employee that rise to the level of a disability under the Americans with Disabilities Act. Wisconsin law is less clear here because generally there must be a permanent impairment before something can qualify as a disability. And I haven't seen any decisions on that yet, but I would expect that they would come out relatively soon. And even if COVID does cause a disability, employees are not necessarily always going to be entitled to a reasonable accommodation under the ADA. Accommodations are still only required if someone had an actual or record of having an actual disability. And accommodations are only required if the disability requires the accommodation and does not pose an undue hardship to the employer. So some of those standard ADA analyses are still in place with regard to COVID, but it just presents another complication, and the EEOC is saying, hey, COVID may cause some of those same issues to arise in employees. Another issue that's important to note with regard to the EEOC is that if an employee is no longer infectious, preventing them from returning to work based on your concern, and I suppose I should say that this means returning to work in the office, based on myth or fear about COVID, could risk violating the ADA, because the ADA prohibits employers from taking actions against employees whom they regard as having a disability. So if someone had COVID and it does not actually hinder their ability to work, we likely should not be preventing them from working on that basis. And finally here, remote work as an accommodation. I think this has probably been discussed before, and current litigation is currently testing the boundaries here. But employers who offered remote work or are currently offering remote work to some employees may now more strongly need to consider offering remote work as a reasonable accommodation to employees who say that their disability makes it difficult for them to do work in the office. So I hope that helps with regard to the COVID situation. I'm happy to address some more questions in the future during the Q&A.
Next slide, Mary.
All right, so here I wanted to just throw up the CDC guidance slide in particular. So what we see here is that it really depends on where you are in terms of the CDC's recommendations around masking. The yellow and green areas are areas in which the CDC does not recommend masking. So you can see how it would be difficult both for employers that have operations in lots of different states to come up with one uniform rule around masking and social distancing, but also hard for OSHA itself when it's trying to enforce its rules.
Yeah, that's interesting. All right, thank you. I want to interject. Please make sure to submit any questions that you have in the Q&A feature. The program is being recorded, as I mentioned earlier, and will be available later today or tomorrow morning on our website. Rachel, what are you seeing with your clients in regard to COVID requirements?
So as Michael mentioned, there's a lot of factors at play here. The Supreme Court decision regarding OSHA's emergency temporary standard, and then the ever-changing CDC recommendations. So our clients are having to take all of that into account when considering vaccination and testing requirements. So our employer clients tend to fall into one of four categories. So first are employers and industries with safety requirements such as healthcare, in which they are continuing or actually required to continue vaccination mandates and are electing to also continue with regular testing protocol. There are also employers who complied early with OSHA's requirements, assuming that the ETS would be passed, but they've now all but abandoned those policies and protocols and essentially are leaving it up to their employees to decide how they'd like to proceed. There are also employers who opted to comply proactively and are continuing testing policies despite the Supreme Court decision. So some of those policies may include temperature checks, regular testing, and self-reporting. And lastly, we have employers who've continued some level of safety precautions. So that might be a mask policy in certain environments, offering free test kits to employees and their families. So we're really seeing employers in many different areas. And not only are they having to make decisions based off of their employee needs and desires, it's also, it depends on if you're a Wisconsin-based employer or if you are throughout the United States. So a lot of things to consider here when deciding how to proceed.
Great, thanks, Rachel. Michael, what are some of the strategies that employers should adopt to position themselves well to confront these new legal realities?
Sure. So there's really no one best way for an employer to reposition itself to meet some of these shifting demands. As we've discussed, employees have shifting demand, the labor market has been complicated, and governments have issued kind of conflicting and changing responses to the pandemic. We haven't even discussed compensation issues. I don't think anyone needs me to tell them that, pay levels are something that affects employee retention. However, it is important to reiterate that your employee agreements that pertain to compensation should be clear about what they provide in terms of what's owed and when it's owed and what happens if an employee does leave, so that you can prevent disputes from arising. But also, employers already have tools in their toolkit to address some of the most pressing issues. They have employee handbooks, they can implement employee agreements, and through those, employees can structure their workplace to improve the employment relationship and make things go more smoothly. So both changes to the employee handbook and agreements can protect you legally and may prevent excessive turnover. So first, I'm just going to touch briefly on some of the specific employee handbooks that would generally be recommended to confront some of the issues that we've discussed today. And remember too, that with regard to an employee handbook, it's generally not enforceable as a contract. And you wouldn't want it to, right? Because you would often have employees taking you to court every time they thought that you violated some aspect of your own policy. Your tools for enforcing something in your handbook are instead the levers of employment itself: discipline, termination, or incentives on the other side. So first, we'll just take these one by one. Remote work policy and program. Obviously, this is something that's a critical issue we've been discussing, but generally either develop one or integrate it into other policies. If you're going to allow employees to work remotely or on a hybrid basis, you can require that they notify you where they're working from, that they maintain confidentiality, that they continue to meet the required metrics that they had when they were still in the office, that they address the technical components of their job. The policy that you implement should also likely address timekeeping issues, especially if you have non-exempt workers who are hourly working remotely. And as with most policies, you should reserve discretion to change the policy if needed. Next, vaccination, masking, and accommodations. I think Rachel alluded to this, but employers are still generally permitted to require COVID-19 vaccinations in order to come into work. And employers should consider implementing policies placing employees on notice that they, even if they don't do so now, that they could change their vaccination or masking policies consistent with public health guidance in the future. All such policies should also require and permit you as an employer to continue to engage in an interactive process or accommodate individuals who request accommodations for a sincerely held religious belief or disability-related reason around the vaccination or masking requirement. Next, I'll take some of these together, but employer technology policy, the terms and condition here, and here I'm referring to terms and conditions that it might pop up on an employer computer, or the terms and conditions that will pop up on a virtual private network that an employee uses in order to access the employer's database from home, but also confidentiality policies in a handbook. These policies should be clear about what employees have access to what sensitive data and where and how they are permitted to access it. So again, these requirements around the technology for accessing an employer's software and sensitive data should be clear so that employees can't access confidential information that they don't need to perform their jobs, and so that you don't end up having confidential proprietary information or some of that PII that we talked about earlier end up on your employees' personal computers. You, as the protector of that information, should also implement different layers of security and access to the extent it's possible. Again, so even if it's password protecting layers of security to prevent employees from getting at all of the data all at once, that's more beneficial than, that's not as good as having it layered so that employees can only access what they need. The policies should also notify employees that storing proprietary information or data on their personal devices could lead to discipline or require the employee to turn their personal device over for forensic examination. Bring your own device policies next. I have this on here because employers should question whether they should allow employees to use their own devices or whether the cost of providing an employer-controlled device is worth the diminished risk that some of that confidential or customer data gets ported or left on the employee personal device. It's also worth noting here that especially for employees who use a significant amount of customer or proprietary data to do their jobs, employers should consider requiring those employees to sign a strong return of property agreement that covers all company data and technology. And here I'll draw a distinction between return of property agreements that cover property that is even data for the employer and confidentiality policies, because sometimes courts interpret confidentiality policies to be restrictive covenants and they're less likely to always be enforced. Next is the electronic communications policy. No longer should this policy just apply to whether employees can access Gmail or Facebook on the work computer. And just as an aside, it's still best to prevent that because both of those sites actually provide a fairly good way for rogue employees to transfer sensitive data or even trade secrets without creating an email trail by sending themselves email with your data in it. This policy should further, though, require employees to practice good email and communications hygiene, like very strong passwords and security mechanisms around phishing. They should prevent them from opening attachments. This policy should prevent them from opening attachments from unknown senders. And also note that employees should only be able to use encrypted storage devices and emails. Next I have on the list is antitrust compliance policy or program. This may come a little bit at left field for people who haven't heard about this, but the Department of Justice has been cracking down on employers that collude with competitors to prevent the hiring of each other employees. So when you begin to think about what can we do to mitigate the effects of the Great Resignation, one thing you should likely not do is come to agreements with your competitors to not to not hire each other employees. Such agreements are potentially criminal, and they're called no-poach agreements. So in that regard, consider adding a policy or a training regimen that helps protect the organization by helping, especially human resources professionals, be on the lookout for such types of proposals from competitors and to obviously not start them themselves. State-by-state supplements or revisions due to remote employees. This dovetails perfectly with something Rachel said before. The more states in which you have employees, the more you need to consider revising your employee handbook. Often employers choose to implement state-specific supplements to their employee handbooks rather than have one size fits all employee handbook that offers, all of the protections of all the laws for all the employees. For example, in California or Illinois, employees are generally owed their expense reimbursements, including, for example, with remote workers, potentially internet charges. And so Illinois allows you to control that to a certain extent with your policy, but a state supplement from California or Illinois could help you do so more easily. So finally here, dovetailing from the discussion about the employee handbooks is talking about developing or updating the agreements that you have with employees. Agreements with employees, again, can do things that your employment handbook cannot. They are enforceable by courts as contracts, and so they are necessarily a stronger tool. First off in the list is the employment agreement itself. Most of you probably have an entirely or almost entirely at-will workforce, where either side can end the employment relationship under the law at any time for any reason. But in the Great Resignation, there may be circumstances in which it now makes sense to reconsider and ask certain employees to sign agreements for a defined term, whether that's 1 year or a little bit longer. Doing so protects those employees from termination, typically except for just cause situations, and it protects you from them resigning early. What it does is it disincentivizes them from resigning early because it allows you to recover certain training costs or fees for breaching the agreement. And I'll be clear here, even for your at-will employees, you can still have an employment agreement that says that they are at will and either party can end the relationship at any time. But having that agreement in place is a good way to get them to sign a strong confidentiality agreement, or again, when it's appropriate, a return of property agreement, which you can use to specify that employees are required to return not just the technology that you allow them to use at home for their remote work, but all the data that they used to perform their job in the case that it's not all stored on your own system. In either way, you are working to get their cooperation to ensure your data security even after they resign. And I'll just offer a note here too that even an offer letter could potentially operate as an employment contract or an employment agreement. So consider that in relation to the communications you have with employees at the outset of employment. I've talked in the next piece several times, so I'm not going to spend too long on it, but confidentiality agreements. Many employees deal with significant financial proprietary information for their jobs, and signing a confidentiality agreement, whether or not that's part of an employment contract for a defined amount of time, it can help you ensure that you're meeting your data security obligations to your clients and those requirements imposed by governments. And so last here, I'll just offer a note about restrictive covenants. They're typically referred to as non-competes, non-solicitation agreements. These are enforceable in Wisconsin in certain circumstances. They're not enforceable in every state. So one issue you have to be aware of is the state law in which you are asking someone to sign an agreement. And by that, I mean, what state law applies to your agreement. And often you can define that in the agreement, but not always. And you may want to consider using one of these enforceable non-compete or non-solicitation agreements to prevent employees that have significant levels of customer engagement, maybe one that they've developed customer relationships for you for a long period of time, but they must be typically narrowly tailored and based on legitimate business interests. So I hope that's been helpful, Dan, and I'm hopeful that we can discuss even more, during the Q&A session.
That was incredibly rich information. Thanks. Rachel, what are some of the additional changes specifically around pre-employment screening that employers can make given the tight labor market?
Great question, Dan. And I strongly believe as a background screener that even in a tight labor market, it's still important to do your due diligence as an employer. So really what employers should be looking at are what are ways to improve their screening process. I always recommend that employers start by reviewing their job descriptions and requirements. Review the job duties and responsibilities. Do they really align with the role? And then consider the experience and education necessary for that particular role. From there, employers can make position-specific screening criteria. So it's not a one-size-fits-all approach. The way you're going to screen for the next CEO or VP of your organization is not the way you're going to screen for most employees. So it's really important to identify the pain points in your process and challenge the status quo. So you want to consider your candidate pool. You want to consider what positions you're hiring for. What's the environment? Is the individual going to be working in a professional office environment? Is it in a warehouse? Is it remote? Is it a driving position? And then you want to consider your employment and education requirements. So when it comes to employment, the IRS requires that employers retain records for, I believe it's 4 years. Michael, correct me if I'm wrong. And so most employers we see retain the records for about 7 years. So anything that's extensive, anything longer than 7 years often can cause delays because either employers don't have those records, or sometimes we even see that employers just no longer are in business. And those extensive protocols don't actually add value to the background check and really just create delays in the process. When it comes to education requirements, it's really important to think about whether or not a position requires a college degree. Now, certainly there are legal requirements or industry requirements. You have to have a JD in order to practice as a lawyer. But for sometimes there's just positions where the default has always been bachelor's degree required. And it's really important to think what kind of barriers to employment might this create for individuals who have extensive employment history. When a college degree is not required, sometimes employers will require a high school diploma, GED, or HSED. And it's worth kind of considering whether having that diploma actually ensures that an individual can perform the job duties. So a perfect example is one of our clients last year reviewed their entry-level positions and determined that a high school diploma did not indicate whether someone could perform the job duties or not. And this was really specific to their CNA positions. So a CNA license you do not have to have a high school diploma to get a CNA license. And they determined that having that high school diploma didn't really dictate whether or not someone would be successful in that role. So they eliminated that process. And in turn, they've shortened their background screening process and they're bringing on talent faster, which is especially important in healthcare. So really it's about thinking about what value do these verifications add? What kind of delays can it create? High school diplomas, GEDs, HSEDs outside of international education verifications are the longest. It takes the longest time to verify. It's not like a college or university that either uses National Student Clearinghouse or some other third party or has a registrar's office that you can easily call. The last thing that that is really important for employers to consider is how they review criminal records. So we recommend that they create a criminal record matrix that really guides decisions regarding criminal records. So outside of industry-specific requirements, the standard that we see is 7 years. And if employers take time to consider past hires, they should really consider how misdemeanors or forfeitures have impacted their hiring decisions. If such records don't have bearing on their decisions, then they should really consider only reviewing felony records. So as I mentioned, criminal record matrices are important. It's also important to have adverse action policies and individual assessment protocol in place. And this will save precious time for your HR and compliance team if you spend the time now creating these documents. Then they're not trying to figure it out when it comes to the hiring process. So updating your screening protocols, it doesn't just impact your turnaround time, it also eliminates a lot of barriers to employment. There are a lot of untapped labor markets out there. So justice involved job seekers, that's a term that we use for individuals who have criminal records. That is a large population of the United States. About 1/3 of the US population has a criminal record. So when you review how you handle criminal records, you could really create opportunity for these individuals and tap into this market. Many employers here today have probably heard of the SHE session. And that refers to women, particularly women of color, who experience proportionately greater job loss during the pandemic. And a lot of these women are mothers. So for many of these women, childcare is really important in determining whether or not they'll return to the workforce. By creating part-time and flexible positions, you can really tap into that market. There's also a market of neurodiverse individuals, and these individuals could benefit from part-time, flexible, and full-time employment. By creating various opportunities, as well as in-person, remote, and hybrid positions, you can really expand your talent pool to fit a wide array of needs. And then additionally, you want to consider how remote work accommodations may benefit individuals with disabilities, people with social anxiety, and individuals with mental health issues. It could also benefit individuals who don't have access to reliable transportation or may not be able to drive. But alternately, you want to consider how remote work may not be the best fit for everyone. So some formerly incarcerated individuals may struggle without the structure of an office environment. And there's some individuals who may not have safe home environments, and coming to work is a bit of a reprieve for them. So as employers, we just want to continue to make reasonable accommodations wherever possible, and continue to foster safe and inclusive environments for our employees. And by doing that, we not only expand our talent pool, we also increase our talent retention.
Great, thanks. That's some very helpful insight. You also mentioned the justice-involved job seekers as an untapped labor market. This is connected to the fair chance movement, which has been gaining traction. Can you share more on this topic? Are you familiar with any programs or organizations successfully working to break the cycle of recidivism?
Yeah, so this is an initiative that's certainly near and dear to my heart. So fair chance hiring is the process of hiring individuals with criminal records. We prefer to call these people justice-involved individuals. So many employers may be familiar with the Ban the Box movement. 37 states and 150 cities and counties have passed Ban the Box or fair chance laws. And of those, 15 states and 22 cities and counties have passed laws that apply to private employers. So this is the movement to remove the criminal history questionnaire from the job application. And it really encourages employers to first consider an individual's credentials and qualifications before considering their criminal history. And there are a lot of employer benefits to this. So as I mentioned before, justice-involved individuals make up 1/3 of the workforce. So this is a huge untapped labor market. But it's one thing I kind of a caveat is this is a talented labor market. So this is not just a marginal pool of individuals that only should be tapped into during, times of tight labor markets. And with that, there's a federal work opportunity tax credit, and that's available to employers who hire individuals who traditionally experience barriers to employment, which include justice-involved individuals. Due to scarcity of opportunities for justice-involved individuals, they tend to be really reliable and loyal employees. And studies show that employers experience lower turnover rates with these individuals. Through fair chance hiring, employers can really help transform criminal liability into a community asset. Individuals who have gainful employment are less likely to recidivate. And you asked about organizations that are supporting this movement. The biggest organization is SHRM, so the Society for Human Resource Management, which launched their Getting Talent Back to Work initiative in 2019. Their initiative includes a free toolkit that focuses on readiness, talent acquisition, onboarding, talent development, and talent mobility. So it really helps prepare employers for hiring justice-involved individuals. And they offer a free certificate for HR professionals and other leaders. And at the local level, there's an organization in Milwaukee called The Way Out. And so they are working on reducing recidivism through technology and living wage jobs. They offer direct hire recruitment through an anti-bias platform. They also have an app for justice-involved individuals. It helps them with professional and personal goal tracking, and employers can incentivize those goals. And additionally, they provide consulting and coaching to employers. So they offer DE&I training. They've also partnered with the Milky Way Tech Hub. And so they are launching a program called Bridging the Gap for Returning Citizens. And it's focused on teaching justice-involved individuals the technology skills necessary to tap in today's workforce. So as a professional background screener, I do think it's really important that employers are aware of fair chance employment and that hiring managers understand what questions can and cannot be asked during an interview. So for Wisconsin-based employers, there are no laws, no fair chance laws that apply to private employers. But if you're looking to expand outside of Wisconsin, it's really important for you to be aware of what laws would apply to you in those markets. And then from a personal perspective as an employer, I think it's that we are in a position to create more change and at a faster clip than our local and state government. So if you are interested in fair chance hiring and if it's important to your organization, you can implement this initiative regardless of what fair chance laws may or may not apply to you. So I recommend starting by downloading that SHRM toolkit and possibly taking that free certification course.
Great, thank you. Sounds like SHRM's got some great resources. Great information. There are a number of questions. If you have any additional questions, please submit those in the Q&A. We have about 10 minutes for some questions, and I'd like to get to those right away. There's one related to fair chance, as you were just describing, Rachel. So in this environment of identity theft and embezzlement, how can I protect themselves or ourselves when participating in fair chance employment? Is there any kind of insurance available?
That's a great question. And actually, I was doing a little more research on this because I know that there are some initiatives in different states to create protection programs for employers. There is nothing in the state of Wisconsin at this time, but one thing that is offered through the Department of Labor is actually a federal bonding program. So in conjunction with the federal work opportunity tax credit, there's a federal bonding program that creates fidelity bonds that cover the first 6 months of employment. And this is actually at no cost to the job applicant or the employer. So that is certainly an option for employers who are concerned about liability.
Okay, thanks. There was a question about how can you expand on neurodiverse labor market? Can you describe what that labor market option is, the neurodiverse labor market?
Sure. So, I mean, predominantly that would cover individuals who are on the autism spectrum. So InCheck has started working with a local organization and we've hired a number of neurodiverse individuals. So that's a term that's used for individuals on the autism spectrum. And really, it's just about creating an inclusive culture in which individuals with all different backgrounds, all different abilities can find gainful employment within organizations.
Great, thank you. Michael, this one might be for you. With the growing remote workforce, when employers had decided the need to terminate a remote employee, what's the recommended best approach doing this?
Well, I mean, with regard to a remote worker, as I think both Rachel and I mentioned during the program, you can still require remote employees to meet the same criteria that you would require them to meet if they were in the office. And generally speaking, when terminating a remote worker, you'd want to be sure that you have your sort of tasks lined up, I think, before doing so, because like I mentioned earlier, you want to be able to retrieve any type of technology or data that person may be under possession of, or you want to make sure you do things like shut off their email address and turn off their access to the virtual private network, if that's the way in which they're accessing your system. But beyond that, I mean, generally speaking, it's the same criteria you can use with regard to them when they're in the office. But those complications around technology and data are the main ones that I would say present a little bit more complication to your decision. I have to also say, I meant to say this at the top, but anything I say in this presentation can't be considered specifically legal advice. It has to be just sort of generally understood that best practices is what we're talking about here today. So anything that I say in regards to a specific question would need to be understood in context of consulting an attorney on your own.
And each individual situation is different.
Exactly. Thanks, Dan.
Rachel, there's a question. Is there a trend starting to drop drug screens and pre-employment process due to labor shortages? I've heard maybe some kinds of employers may not test for marijuana. I heard that, I don't know, within the last several months, but you would know much more about that.
Sure. So yeah, we do see a lot of employers who it's basically employers who used to do a 5-panel drug screen, and now it's a 4-panel drug screen. So it doesn't include testing for marijuana. And there are certain laws in different states regarding marijuana testing in pre-employment scenarios. And those may vary then between pre-employment and then current employment. I'm not an expert in the legal field on that, but that is certainly a trend that we are seeing. In regards to dropping drug screen entirely, I guess my question for an organization considering that, given the talent market, is considering why was drug screening implemented in the first place and whether or not it's a good fit for your organization. But we have a lot of safety sensitive clients with safety sensitive positions, so we're not seeing any changes there regarding drug screening. And we haven't seen a major drop in where clients are reaching out to us saying we just want to eliminate the drug screening process entirely. I didn't touch upon that today, but there are certainly electronic solutions that screeners can provide to at least expedite the process of drug screening through candidate self-scheduling portals, as well as rapid testing. So rather than doing lab-based testing, employers can do rapid testing, and you generally will have results within 24 hours.
Okay, great, thanks. Can employers deny requests for remote work based on the location that the employees wishes to work from in order to avoid a state income tax filing responsibility for a state where they do not already do business or have any other employees?
Look, I'll go first on this one. I believe so. Generally, I believe that's the case. Like I mentioned earlier, if you have an employee working remotely in California, California has a very broad expense reimbursement policy that generally requires you to undertake the cost of some portion of their costs for remote working. That cost is not required in a lot of other states, including in Wisconsin. So that is a reasonable basis to decline to hire someone in a different state on a remote basis. I'm not aware of the specific tax-related implications that you just mentioned in terms of avoiding having to file an extra tax form, but assuming they stem only from the decision about whether to employ someone there, I have no reason to think that it would be problematic.
Mm-hmm. Rachel, anything? No.
No, I'll trust Michael there.
Yeah, great. Another question. If I incentivize my current employees to get COVID-19 vaccines, do I need to offer the same incentives to new employees coming on board now?
That's a good question. I don't know the answer right off the bat. I hesitate to say yes, you have to, but I would say that it's likely a best practice if you're suggesting that should I? The question was new employees get incentivized, but current employees, do I have to incentivize them? Is that right?
No, the incentive was for current employees. I don't know, maybe it was giving them $100 or a day off. If a new employee joins, you have to retroactively go back and offer that same incentive to the new employee that's coming on board to get a COVID test.
Oh, I see. In that way, no, I do not think it is required to offer to new employees. In general, with regard to the incentives for getting vaccinated, take a look at the EEOC guidance and regulations around that, because at a certain point, you don't want to interfere with individuals who are disabled and unable to get vaccines or have religious objections to doing so. It could be problematic under the discrimination laws.
Great point. Just a couple more questions. Rachel, you mentioned that in addition to applicant tracking systems and HR software, there's some more low-cost options for employers looking to update some of their paper-based onboarding processes. Can you share of some of those low-cost options?
I'd be happy to. So I had mentioned e-sign software. So that's certainly a solution for applicant tracking systems and HRIS systems. Those are incredibly expensive softwares, and there's certainly a varying degree of cost there, but e-sign documentation or software is a great solution. So Adobe Sign is one that comes to mind, but there are numerous ones online. I think PandaDoc's another one that I've seen. You could Google e-sign software, and essentially what you can do is take your forms, take your documentation, and move it into an e-sign platform. I can't speak to the legal side of that and the privacy and data protection side, but there's certainly solutions available. This is also beneficial for anyone who has, employer contracts with clients, and they're no longer seeing their clients in person and would like to have contracts signed electronically. Also, there are third-party screeners that offer technology solutions, which include electronic consent forms. So this doesn't really require that employers invest in all this different technology in order to transition from in-person to remote. There's certainly other opportunities out there.
Great, thank you so much. Michael, one last question. On slide 14, we don't necessarily have to go back to it, but you talked about remote work policy, the program, vaccinations, confidentiality, bring your own device. What are some of the risks for not making these best practice changes? And can you give some specific examples? What kinds of exposures do you have where, employers have dealt with the COVID situation for the last 2 years, and oh gosh, I've got to update all my manuals now.
Right.
It sounds like it's pretty serious. What are the risks by not updating those types of things?
Right. So it does depend on the policy. At this point, as I mentioned before, I don't think there's a large risk for an employer who decides at this point to not implement a COVID-related vaccine testing masking policy. That could change if the CDC's guidance changes and the OSHA starts enforcing consistent with that guidance. But in contrast, failing to implement reasonable safety measures with regard to your confidential and proprietary information, that can be an issue along a lot of different fronts. You're risking that employees have easy access to sort of your secret sauce and making it easy for them to port that onto their own personal device. If you do so, it makes it harder to enforce them in court as a trade secret. And you don't have the ability to, if you don't have potentially a contract, but also a confidentiality policy in there, then you may be without certain tools in your toolkit if you go to court, because a judge is often more likely to grant a temporary restraining order requiring an employee to return something that they took if you have a contract sort of laying out specifically what they're required to do, versus having to go in and say, this was my trade secret. Often that requires a lot more proof and information you have to present to the court. So it really does depend on the policy. Again, all of these were sort of best practices, especially with regard to remote employees. But a lot of times there are ways to implement them particular to each workforce.
Okay, great. Well, time is up, so we should move on. But before we do, Rachel, I want to give you one, what's the last word from your perspective as it relates to this important issue that we've been talking about?
Yeah, it's based on a lot of the questions that we've heard today. I think employee retention is a really big part of it, and how that can be done by small businesses that don't have a lot of money to throw at benefits and salary and other employee engagement tools. And really what I want to stress is that employee retention really starts with culture. So focus on your company culture, focusing on inclusion, and focusing on making sure people feel valued when they come to work. They could have gone anywhere. Why did they choose your organization? And just one thing that I wanted to throw out there for anyone who wants to take a look, there's a really great video by Accenture called Inclusion Starts with I. I know there's questions that we didn't get to today about how do you ensure that how do you retain employees when you're a small business, or how do you address the New York Times article regarding childless employees and how the burden that they may feel because they are expected to do more. If you look at that video, everyone feels something. Everyone feels some level of expectation from their employers and their people around them. And so if you can start that conversation and really create an environment in which people can be open about what they're dealing with, because we all bring something to work, I think that's a really great way and essentially a free way for employers to really focus on employee retention in this kind of market.
And you cited some that your company does that sound a lot of fun and
Yeah.
engaging to help your culture.
I think
Michael,
so.
yeah, Michael, last word?
Yeah, thanks, Dan. I mean, I really couldn't say it better than that, but you know, I think employees appreciate being listened to, being understood, and having the opportunity to have input in the workforce. Alongside of that, you know, I think employees appreciate clear guidelines, whether it's your handbook or those agreements that that clarify, you know, this is the shape of the employment relationship, in order to kind of get that buy-in from employees and really all be mission focused together to kind of build the organization.
Great. Thank you so much. Well, thank you all for attending, and thank you to our presenters and partners, Rachel Moravchik with InCheck and Michael Gentry with Reinhardt Berner Van Buren. These are the experts. Make sure to reach out to them and their companies if you have any additional questions regarding pre-employment background screening services and the legal landscape that employers must confront today. As I mentioned earlier, this webcast recording will be available on our website later today, or for sure by tomorrow morning. And the slide deck is available now. We value your feedback, and we look to have more of these webcasts in the future. So please, we would appreciate if you fill out the attendee survey, which will open in a new tab once you close the webcast tab in your browser. So again, thanks so much on behalf of our webcast presenters and partners, InCheck, Reinhardt Berner Van Buren, and BT360 Content Solutions. Thanks again for attending, and have a great rest of the day. Thanks,
Bye.
everybody.
Thanks, Dan.
Thanks, everyone.